Hello and welcome back to State and Local Government and Politics. In part 2 of Module 8 on the courts, we'll discuss state court systems. Unlike other countries with a single centralized judicial system, the United States operates under a dual system of judicial power. One system of courts operates within each state's constitution, and the other system of courts derives from the provisions of Article 3 of the United States Constitution. Each state, as well as the federal government, are responsible for enforcing the laws, and state and local courts and federal courts adjudicate both civil and criminal case matters. It follows that Americans are dual citizens. Not only are they citizens of the United States of America, but they are citizens of the state in which they reside as well. Except for the appellate process and possibly the procedural realm of injunctive relief, the national and state courts are virtually separate and distinct entities. For example, since the U.S. Constitution gives the U.S. Congress authority to make uniform laws concerning bankruptcies, state courts largely lack jurisdiction in the matter. On the other hand, the U.S. Constitution does not give federal government authority over the regulation of family life. In matters of family law, for example, divorce, child custody, probate, division of property, and so forth, a state court would have jurisdiction and a federal court would not likely hear cases. While operating largely separately, the two systems can come together in the U.S. appellate courts, including the U.S. Supreme Court. The U.S. Supreme Court has final interpretive authority with respect to disputes regarding the meaning of the U.S. Constitution and interpretation of its provisions by all inferior courts in the country when there is a federal question. This occurrence is relatively rare. State courts were in place after the American Revolution, but with fresh memories of the colonial court's control as an extension of English rule, Americans generally distrusted these state courts. Since states were predominantly rural in the distribution of their populations, conflicts between people tended to be relatively simple and were typically settled informally without the need for court intervention. It wasn't until the mid-19th century that modern, unified state court systems emerged, with many of these upgrades in the procedures and practices of minor courts coming in response to the many new legal challenges arising from the Industrial Revolution. With industrialization, the American society was changing so rapidly in so many areas that state legislatures, most of which met for only brief periods of time, neither had the time nor the resources to develop statutes to cope with the rising problems. This set of circumstances resulted in many conflicts entering into state courts through parties asking the courts to use their common law equity powers to resolve contentious commercial, real estate, industrial insurance, and similar disputes born of a rapidly industrializing nation. Common law is a system of legal principles established on judicial precedents rather than statutory laws. They may be codified into statute or overruled by a statute passed by the government. While general jurisdiction county courts were well established in American society and enjoyed growing legitimacy as the memories of colonial rule faded over time, these courts were neither adequately staffed nor properly organized to address the increasingly complicated problems of the day. General jurisdiction courts are courts that deal with both civil and criminal cases and whose jurisdiction is based on geographical area. When state and local courts became overwhelmed with litigation and lost faith in the legislative process to bring timely relief, the state bar associations, the professional license associations of lawyers in a state, began to orchestrate reform in state court systems. This reformation depended on the separation of powers argument that empowered state supreme courts to create unified courts by mandate of the court. More specifically, state supreme courts acted on their own authority as a separate branch of government, establishing a system of courts wherein the state supreme court sits atop a system of interconnected courts, all of which adhere to the same rules and procedures on how cases are processed and appeals are made. This creation of unified court systems resulted in the addition of new jurisdictions, the development of uniform procedures, the common training of court personnel, and in many cases the development of specialized courts, such as small claim courts, juvenile courts, and family law courts. In due course, state legislatures codified the key elements of unified court operations into state statutory law. Through the U.S. Constitution, Article 3, Section 1, the U.S. Congress has the power to establish inferior courts for cases arising from federal law. As previously noted, the interaction between the federal and state courts is relatively rare, with the most notable exception being in the area of civil rights. Federal statutes, such as the Civil Rights Act and Voting Rights Act, can and have brought the federal and state court systems into close contact. Though federal and state court systems happily coexist in many respects, such mutual coexistence is not uniformly the case. For example, during the 1960s, there was so much conflict between federal and state courts that a U.S. constitutional revision was proposed calling for the creation of the Court of Union, a judicial tribunal that would have addressed the alleged encroachments upon state judicial power by the federal system. Even though the Court of Union idea ultimately failed to gain traction with either the public or the legal community, the conflict between the two systems that gave rise to the idea has not fully abated. An example of this conflict is the deep disagreement over capital punishment arising in late 2007. While waiting for a U.S. Supreme Court decision as to whether the current method of lethal injection represents cruel and unusual punishment, a violation of the Eighth Amendment of the U.S. Constitution, many of the 36 states using lethal injection as a method of execution placed a de facto moratorium on executions. On November 2, 2007, barely a month after the U.S. Supreme Court agreed to hear the case or granted certiorari on lethal injection, the Florida Supreme Court unanimously ruled that their state's new method for carrying out lethal injections, after changes in the procedure were made, which were prompted by a botched execution in December, do not violate the U.S. Constitution's prohibition against cruel and unusual punishment. Certiorari is a writ of a superior court to call up the records of an inferior court or body acting in a quasi-judicial capacity. In Part 3 of Modulate on the Courts, we'll discuss how state courts work.